Hear ye, hear ye. Justice and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning, ladies and gentlemen. Our first case this morning is 2019-488, Dennis Stiner versus Amazon.com Incorporated. For the appellant, Mr. Balzer.
Thank you. Chief Justice O'Connor, and if it please the court, my name is Brian Balzer, and I represent Dennis Stiner, the administrator of the state of Logan Stiner. I would like to reserve 4 minutes of my time for rebuttal. Just days before his high school graduation, Logan Stiner unknowingly consumed a lethal amount of pure caffeine. This pharmaceutical-grade caffeine powder was purchased on Amazon.com. Kelsey Kidd had never heard of the caffeine powder until she placed pre-workout into her search on Amazon.com. Amazon's patented A9 algorithm selected this deadly product for her to buy. Amazon had listed the product on its e-commerce marketplace, and before the caffeine powder was selected for Kelsey to buy, Amazon had received several safety concerns, including that a small amount could cause accidental overdose and death. Amazon controlled the entire sales transaction, from selection to completion of the purchase of Kelsey. But for Amazon's participation, this deadly powder would not have been placed in the stream of e-commerce, and Logan would still be alive. Amazon's position that they are only providing a platform for their selling partners to peddle their products is a myth. Not only does Amazon's position ignore the realities of today's e-commerce transaction, but also is contrary to the underlying policy reasons for which strict liability was adopted. In today's world of e-commerce, the facts of this case and the policy reasons for Ohio strict product liability support defining Amazon as a seller or a supplier under Ohio law. Defining a seller or supplier for e-commerce transactions, we look to the public policies underlying strict liability, protecting the consumer from unsafe and dangerous products, preventing circulation of dangerous products, incentivizing safety, and shifting the risk to the entities that can allocate the risk that the products sold on will be defective. Holding Amazon, a seller or supplier, accomplishes each of these policies under the facts of this case. Amazon was and is in the best position to protect consumers from unsafe and dangerous products and prevent the defective and dangerous products from being placed into e-commerce.
Also, I wonder if you could focus in on the statutory language of what a supplier means in Ohio.
Yes, Your Honor. In terms of in Ohio, the statutory language and what's at issue in this case is a person that in the course of business conducted for the purpose sells or otherwise participates in the placing of a product in the stream of commerce. That provides a very broad definition of seller supplier. And actually, during oral arguments in the Fox case in the Sixth Circuit Court of Appeals, Amazon's counsel told the court that Ohio's statute provides a broad definition of seller. Mr. Murphy's argument to the court was that it's much, much broader because it includes the phrase otherwise participates in placing the product in the stream of commerce. That's the language that was used by the Ohio General Assembly. And the Ohio General Assembly uses words for a reason. They chose...
Counsel, what does our precedent say about what those words mean, placing something in commerce?
I guess we'd have to look at this court's decision in the Anderson versus Olmstead case, in which they used the exact same language that the statute has in terms of placing it in the stream of commerce. And then you have to look at the underlying reasons. If we're defining what is a seller or a supplier, we have to look at the underlying reasons, the policy reasons, to determine whether they're just a small actor and really couldn't make a difference, if they're like Amazon was.
Excuse me, Counselor, you keep asking us to look at the underlying reasons. Does that mean you don't think the language itself supports your position?
No, I do. I absolutely feel as though under the facts in this case that the otherwise participate in the facts in this case do support our position.
Okay, well, I'm trying to get there based on the statutory language, not based on your policy reasons, because that would seem to always counsel for liability no matter the case. So I think we have to look at what language the legislature chose to use and what that means. So under your reading, they're a supplier. Why? Because they made it available on the internet?
Well, Your Honor, they did much more than that. What they did was they listed the product. They made a decision to list the product. They selected the product.
Okay, but help me with each one of those. Which one of those makes them a supplier? For example, is eBay a supplier?
I'm sorry?
Would eBay be a supplier?
eBay has a different agreement in terms of eBay does not have the control of the sales transaction or the listing that Amazon has. So it's a different contract that eBay has. Amazon totally controls the transaction. They control the listing based on what they call the BSA, which is the Business Solutions Agreement, which is the agreement that Amazon has with their selling partners, and it dictates every transaction that occurs on Amazon.com. It is different than an eBay agreement.
Counsel,
eBay,
excuse me, how do you address the fact that Amazon never had control of the product?
Okay, in terms of that, you don't have to have possession to participate in placing it into the stream of commerce. Actually, I would turn the court's attention to Damon Jones, who was identified as the witness for Amazon, the 30B5 witness, and that's in the record at 326. And on page 109, he specifically was asked, why does Amazon, under the agreement, why are they entitled to collect all of the sales proceeds? And he said, because one of the reasons was because it allows Amazon to control the transaction and it eases the flow of the product. So in terms of that testimony alone shows they control the entire transaction and they ease the flow of the product. They have total control.
Counsel, what does that mean? Counsel, what does that mean, ease the flow of the product?
Well, in terms of that testimony, it means they control when that product is shipped. Their third party's supplier, or Tencoris in this case, they are not involved in the sales transaction at all. They basically, all they do is
they get the word from Amazon that a consumer has enlisted or has paid for this product. Go ahead and ship it, and here's where you ship it to, and here's the amount you ship, etc.
Exactly, and based on Damon Jones' testimony, Tencoris is not allowed to do that until Amazon has completed the purchase, has completed the transaction. Then they send them an email and with the information that you just explained, along with a shipping label. All they have to do is push the button and print out the shipping label. They're not allowed to have any other contact with the purchaser, and in this case with Kelsey Kidd.
Well, it works to the advantage of the Tencoris to make sure, Amazon is making sure that it's a complete transaction. You're paying with a credit card or some other method, and that's valid. And then I'm presuming that's what needs to take place. And then Amazon will pull the trigger and say that Tencoris can ship it. Is that correct?
Absolutely.
So they're a clearinghouse for the financial transaction.
Well, not just the financial transaction. They're more like a sales agent because they're the only ones that communicate with the purchaser. As a matter of fact, they're not even allowed. The Tencoris is not allowed to even contact or have any information regarding Kelsey Kidd. So in terms of that, they're more like a sales agent.
Well, why would they need to have any contact with the consumer here?
Well, because in terms of it, there's a problem with the product. Let's say, like in this case, this was on Amazon.com for over almost 4 years, and there were a lot of safety concerns that Amazon was aware of. Tencoris was not aware of those. There is no way for the consumer to notify the supplier in this case that there are problems or safety concerns with the product. So
well, when you say supplier, do you mean Tencoris?
I mean Tencoris, yes. They're the supplier, or they're the selling partner is the word that Amazon used during the congressional hearing to explain the relationship.
When you say that Tencoris is not allowed to have any information on the consumer, how do they get the product to the address?
Correct. They're not allowed to have email. They're not allowed to contact them. Very limited information are they given.
So they are given some information now. They have to know where to send the product.
Just the shipping information once the transaction has been completed. And so they won't know where to ship the product until Amazon tells them. So Amazon is participating in the sale.
If there's a problem with the product, how does the consumer relay that product? Let's say the container was open when the consumer received it.
They have to go through Amazon. They are not allowed to have any contact with 10 Course or with the supplier.
Then Amazon contacts the supplier about the problem.
I would assume, yes.
Counsel, is that standard universal policy of Amazon that the folks like 10 Chorus or businesses like 10 Chorus cannot have any contact with the consumer?
Yes, Your Honor, it is right in their BSA. If there's any contact, it would have to go through Amazon. So if there's a problem with the product, Amazon actually provides an A to Z guarantee. In other words, they guarantee that it's what you thought you were ordering. They guarantee that you can send it back to Amazon. You don't take it and send it back to 10 Course or their selling partner. It's through Amazon and it's to Amazon. Amazon controls all of that information. And in this case, Amazon, before they selected the product in terms of participation in placed in the stream of commerce, they were aware that just a small amount of this product could kill or could be lethal, because they already have it set up, algorithms that when there are key safety words such as die, death, they are alerted. Their safety team is, and what they then do is they investigate whether it's safe to continue selling on Amazon.com, because we all trust that what they have is safe. And I'm concerned about running out with the time that I have for rebuttal, but Amazon's safety team is not allowed to investigate third-party products based on their policy. They only investigate the ones in which Amazon list themselves as the seller.
So they don't put this product through their associating with the algorithm that death, die, dangerous or whatever.
No, they absolutely do, but the policy states do not investigate. File the concern in a shared mailbox and move on. The only thing they investigate are theirs. They don't investigate safety concerns on the third-party products. If they're subject to strict products liability, it would be an incentive for them to make sure all the products are safe, not just ones they think that they would be liable for. And I would like to reserve my remaining 2.5 minutes for rebuttal, if I could, Your Honor.
All right. Mr. Murphy.
May it please the court, Brendan Murphy for Amazon.com. I would like to start with the statutory question that Justices I believe French and DeWine asked about before I proceed to address some of the factual inaccuracies, which I'll address if I have a little bit of time. Product liability in Ohio is a matter of statute and only a matter of statute. In 1988, the General Assembly took product liability out of the common law realm and carefully balanced the interests and defined the entities liable and the conditions under which they would be liable. And it provided a definition of supplier. That is the legal issue upon which this appeal turns, is whether Amazon qualifies under the statutory definition of supplier, and it does not. The statutory definition begins with 7 action words: sells, distributes, leases, blends, packages, and so forth. And there's really no dispute, and there never really has been a dispute, that Amazon did not do any of those things. Amazon never touched the product, didn't set the price, didn't offer it for sale. Those were all done by 10 Chorus. I don't think any of that is disputed. So this case turns on whether there is room within the otherwise participates in the placing in the stream of commerce language for these broad concepts and undefined concepts of promotion, of being somehow indispensable to a transaction, or importing.
Counsel, is that where the line is, the physical control? If Amazon had taken this product into one of its storage facilities before it was distributed to the consumer, would that have made a difference in whether they had crossed the line?
No, and that is the precise issue addressed by the Fourth Circuit in the Erie case involving the Fulfillment by Amazon program. Fulfillment by Amazon is a logistics service where certain sellers choose to send their inventories to Amazon fulfillment center for storage in the seller's inventory. The seller keeps title, and then when a customer like Kelsey Kidd places an order, the fulfillment center hands that from the seller's inventory to a shipping carrier like UPS. So if possession were the key, then that would be an incredibly broad proposition. FedEx, UPS, DoorDash, entities like that who do have physical possession of a good would then be liable. So it has to be something much more significant than possession. So possession. So
if it's not possession, you listed these 7 items. And I think your argument is that the otherwise participates has to be like those 7 items. What do those 7 items have in common? What is the category we're looking at?
So the commonality among those 7 action words is some sort of ownership or control of the product. You don't necessarily have to own a product to label it or whatnot, but you have to have some sort of control over it.
The fulfillment center would control the product.
I'm sorry?
The fulfillment center would control the product.
Well, only in the sense of having physical possession. It doesn't do any testing or anything like that. So it can't be just physical possession, because that's simply an overbroad conception that would sweep in everybody. And I want to make clear that this is not an FBA case. This is a case where the merchant, Tencoris, shipped it directly to Kelsey Kidd after she placed the order on with Tencoris on Amazon.com. So the commonality is ownership or control of some kind, plus some sort of hands-on action with the product. Deciding what the label is, putting it on there, deciding what the package is going to be, putting it on there. And this court gave a couple of examples in the Anderson case in 1991. That was the overhead lift case, where it was talking about what it means to place something in the stream of commerce. Now, that's a pre-OPLA case, even though it's after OPLA was enacted. The accident was pre-OPLA. But the court cited 3 cases: Perfection Paint from Indiana, Delaney from the Second Circuit, and the Cessna case, I think, from Alabama, that gave 4 examples of what placing a product in the stream of commerce is. One would be sale.
Before you get there, Mr. Murphy, I guess what will be helpful is trying to understand this otherwise places in interstate commerce. If it doesn't mean this, what does it mean? Give me some examples of what that language would cover.
Oh, certainly. And I'll give the examples from Anderson. Providing a demonstration unit, providing a free sample. Perfection Paint, for example, discussed in Anderson as a lead example, involved providing a liqueur to remove some paint from the floor that ended up causing a death. So those examples all involve the entity selecting a product and providing the product, not just physical possession, because any number of entities may have physical possession of a product, but not any kind of meaningful control. So the 4 examples from the 3 cases discussed in Anderson are sale, lease, demonstration unit, and free sample. There, you could conceive of other cases like Torres versus Goodyear or Castle versus Remington Arms. Those were Arizona and California cases involving trademark licensors who essentially design the product and license out the design, but wouldn't necessarily fall within one of these 4 things, but they, for all practical purposes, are designing and making the product just sort of by virtue of their corporate relationships, sourcing out to other entities. So it's not by any means.
Excuse me, counsel. What's your response to opposing counsel's argument that Amazon's algorithm selected the product?
There is no record support for that claim. I would direct the court's attention to record 189 at pages 56 to 59. That is the Kelsey Kidd testimony where she talks about how she came to select the product. She went onto Amazon.com, she typed in pre-workout, and a number of products were listed. She then clicked on one of those, and only after she went into that second level of selection did she see or testify that she saw the hard rhino pure caffeine powder as listed as one of the things she might want to buy.
Who orchestrated that? orchestrated from hopping from one product that originally shows up, you click on that and then it goes to the other? Is that Amazon?
No, that was Kelsey Kidd. She is the one who clicked on it, and she was very clear that she actually said she chose.
Okay, wait a second. She puts in pre-workout. This product, a list of products come up. She clicks on one. That directs her to another product, a similar product, right?
No, that takes her to the product detail page for the product that she had selected. And then once you're on the product detail page, there are other listings. There might be sponsored products. There might be products you might like.
Right.
Products other
Who
people
creates that? Who creates that page?
The algorithms that do the search results, that is Amazon. I'm not an expert.
Amazon promotes or brings to the attention of the consumer at various stages in the search products based on algorithms, and you can go down, a rabbit warren trying to, on your way to selecting a product. I think we've all done that, correct?
Certainly, and this is search functionality that pretty much any effective website does provide. For example, when you go into DoorDash.
All right, we're not talking exclusivity here on this, process. Does Tancoris sell their product through any other format?
Yes, and that's very important in responding to the claim that this was somehow indispensable. Ken Olsher testified, this is at our record 282, pages 12 and I believe 74, 12 and 72. He testified that Hard Rhino pure caffeine powder was sold on eBay and on Tancoris' own website. So Amazon was absolutely not indispensable or crucial or somehow responsible for introducing this product.
Do you know the percentage of transactions for this product, the bulk or the majority through Amazon or through Tancoris' own webpage or eBay?
I don't have that number handy, and I don't believe it was addressed in Mr. Olsher's deposition, so I don't think it's in the record, but I don't know that for sure, Your Honor. But
Mr. Murphy,
I think
can we go? I'd just like to go back for a second to the question I asked you before, because I'm still trying to understand what this otherwise participate covers. And some of the examples you gave me, I think most of the examples were things covered by the first term. So what would be excluded by that language? What would not be included in that language, but only encompassed by otherwise participates?
Well, I don't think that the cells would necessarily cover the instance of a demonstration unit. For example, you go to Kia to take your car in for repair, and they give you a loaner or a demonstration unit. That would not be a sale. That would not be a lease. That would be like some sort of a licensing arrangement. So that would be an example. Something like Cars to Go, where you would have a license to use a car for a couple of hours, perhaps.
Isn't that a lease, essentially?
I don't think that's how a lease is conventionally understood in the car area. I think that's more of a licensing arrangement. But the trademark licensing examples I gave, Torres versus Goodyear from Arizona, Castle versus Remington Arms, those are situations that did not involve a sale, a lease, preparing, blending, anything like that, where the court said there is such extraordinary involvement in the creation of a market for this product and in influencing the design of this particular product that they are going to be treated as a seller under 402A. I don't think those situations would be encompassed at all by the first 7 terms. I can see how that sort of extraordinary involvement, which is way beyond anything any internet marketplace provides, how one could think that might fall within that term. So it's not a null set. We're not up here contending that otherwise participates is a null set. So I think the critical thing, though, is that promotion and these concepts of neutrality or indispensability, those are nowhere in the statute. And if those were read into the statute, one, that would be contrary to legislative intent. The intent of the General Assembly in 1988 was actually to restrict liability, restrict supplier liability, not to add new components, not to return or not to go into some sort of a vague multi-factor policy notion of what a supplier is. And that was along the lines of what other states were doing. In fact, about half the states now have some sort of protections for sellers, because as is evidenced in House Bill 1's legislative history from 1988, as is reiterated in Senate Bill 80's history or uncodified portion from 2004, there has been a widespread reaction to the idea that there should be an expansion of liability. The history of strict liability from the 1960s and 1970s is a retrenchment of liability and a recognition that things went too far. And that makes sense, because if we were to expand liability based on promotion or on vague policy notions of being able to compensate or have some sort of ability to do something with the product, that's practically limitless. Imagine companies like DoorDash, Grubhub. Those are entities where you go on, you put in a search, you might search for an Italian restaurant, and it gives you search results, and you choose among them, and they process the transaction, they handle the communications, you're conducting the entire transaction on that website, on that marketplace. And if the court were to adopt the liability rule proposed by the plaintiff, or to read something new into OPLA, who knows where liability would end? It's practically limitless. So to address a couple of the cases, or actually, I wanted to address a couple of the things that plaintiffs said that are factually inaccurate. One is Ken Olcher, the president of Tencoris, was very clear that you can communicate with, that Tencoris could communicate with users on Amazon.com. That's at record 282, pages 97 and 134. Amazon provides the buyer-seller communications tool. The buyer and seller absolutely can communicate with each other. If you just go on Amazon.com, you can see a button saying contact seller. This idea that Tencoris had no access to any information about its own product is also unfounded. The safety information that plaintiff is talking about is in the customer reviews that are published on Amazon.com. Everybody has access to those, including Tencoris. And this idea that Mr. Jones testified that there is no investigation or response to third-party products is unfounded as well. That's in record 326, page 55, where he was clear that the product safety procedures absolutely do apply to third-party products. In my last 25 seconds, I will just conclude. The General Assembly balanced various policies and decided who can be liable and under what circumstances. OPLA does not permit supplementation with promotion or other vague notions of policy or other things like indispensability. The Ninth Circuit correctly held that Amazon is not a supplier of a product that it did not sell, package, label, or touch. Thank you.
Counsel, you have about 2.5 minutes.
Thank you, Your Honor. I'd like to touch immediately upon Kelsey Kidd's testimony.
Before we get to the testimony, if we accept your understanding of otherwise participate, why did the legislature put the first 7 terms in there at all? Why not just say whoever participates in the placement of a product in commerce?
I think the reason that they placed that there, Your Honor, was because times change. In terms of business transactions, they change.
Right. But that would counsel for leaving out the first 7 terms and just say whoever participates. If we
it's not an and, it's an or. It's a conjunction. So what they did know at the time that they wrote that statute were what they listed. And in terms of or otherwise participates, this product does not get into e-commerce without Amazon's participation. Going back to
right, but I think you're missing the point. Why would you need to put everything else? If times change doesn't help your argument. That's the other way.
I think they also followed this court's unanimous decision in Anderson. They used the exact same language that the court used in terms of stream of commerce. So in terms of that, they followed the exact same language that this court used. In terms of placing the stream of commerce, the result on the A9 patented algorithm they selected each of the products that Kelsey Kidd said. Her testimony was that she put pre-workout on it, and underneath it, it says products you may like at the bottom, and it was one of those products. She didn't have to go any further than that. Any of the products that she saw were selected by Amazon. And then that started the placement into the stream of commerce, because then she decided to purchase that product which had been listed. Then she had to complete that purchase through Amazon. She wasn't allowed to leave that website. So they control that entire.
Well, counsel, I asked Mr. Murphy what were the methods by which Tencoris can't, distributed or sold its product. They have their own website. eBay carries it and Amazon carries it. There may be other places. I don't know if that was an exhaustive list. So when you say that she was restricted or could only get this product from Amazon, that's not accurate.
Well, actually, she could have bought it somewhere else, but she was on the Amazon website. It doesn't take her anywhere else. Amazon controls that. And based on the discovery in this case, the majority of the sales were through Amazon. There were over 1,500 in the state of Ohio alone on this product over a 4-year period.
Okay, do you know the answer to the question I asked Mr. Murphy about whether Tencoris, what's the proportion of their sales, from their website, eBay to Amazon?
Yes, Your Honor. In terms of the discovery request and answers to interrogatory, the large portion was on Amazon.com based on the response.
What does that mean, large portion?
Well, in terms of it, I would say it was probably between 75 to 80%, if my memory serves me correct. And as soon as Amazon no longer allowed them to sell this product, they had to file for bankruptcy, because they were not able to bring any of the sales drop that dramatically for all of their products, not just this one.
Do you think that was related to the safety concerns or the fact that Amazon it's probably both.
They had other products though. It wasn't just they were selling other products than just this pure caffeine powder with Amazon as a selling partner. And in terms of the algorithm and what was mentioned by Mr. Murphy, Amazon is the only one that has an algorithm that pulls up the safety concerns and alerts their product safety team to any potential safety concern. And if it's a product that's Amazon is the seller of,
is there just like some line here that if an internet web service does a really good job or does a few more things, it crosses that? So eBay's on one side, but if eBay provided a few more services, then it'll become a supplier. And what is that line?
I think we specifically have to look at the facts of each of the cases and the control that they have. And Amazon had total control in this case. And over the transaction, over the selection, they totally control what is on the website. They have the ability to immediately halt a sale, to stop a sale, to take down a product when they know that it's dangerous.
Counsel, did the promotional fee that the manufacturer paid Amazon play into the algorithm that brought it to the screen in the search?
In terms of what they paid, no. The only thing that the algorithm A9 is concerned about is the ratings that it has, whether they deliver the product on time, and if it's the lowest price. And actually, based on the relationship that Amazon had with Tencoris, Amazon sent Tencoris an email suggesting that they lower the price on their pure caffeine powder. So that goes to another control issue that Amazon has. And that's in Tencoris Bates number 22386 in this case. So
thank you, Counsel. You've used your time.
Okay, thank you, Your Honor.
Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision.